Individual rights to equal protection under the United States Constitution. A law that discriminates against groups of individuals based on their age, race, gender, or other criteria will be struck down as it violates the individual's right to equal protection under the Constitution. A law that appears neutral but is applied in a discriminatory way will also violate the equal protection provisions. For example, the Supreme Court found it unconstitutional for the city of San Francisco to issue laundry permits to white applicants when it refused all applications from Asian applicants. The city argued that the regulation did not discriminate on its face. It did not state that applicants of Asian origin would be refused permits. Although the discrimination took place in the way the law was applied, and it was facially neutral, it still amounted to unequal treatment and an unconstitutional deprivation of the equal protection rights of Asian applicants. It may seem obvious that discrimination must actually exist in order for this rule to apply. However, equal protection challenges have been brought in situations where there's no discrimination, just a difference. For example, if the government sets regulation setting a licensing test for a profession, and the test is passed by many more female applicants than male applicants, this is not discriminatory, as both male and female applicants have the same test. The fact that more females pass than males is not the result of discrimination. A claim of discrimination under the equal protection rights of the Constitution here would fail. In considering equal protection decisions, the court decides based on one of three tests. In the first test, strict scrutiny, the burden is placed on the government to prove that the law is necessary to serve a compelling state purpose. This is applied to racial discrimination and almost automatically fails. The government almost always loses. The burden is on the government in the second intermediate scrutiny test to prove the law substantially serves an important government interest. Under this balancing test, the government sometimes wins, sometimes loses. In the third minimum scrutiny or rational basis test, the government almost always wins as the burden is placed on the individual to show that there is no rational basis for the government's position. Any conceivable basis for the law under this test will validate the government's position. The court uses the rational basis test usually to uphold government legislation discriminating on the basis of age and other cases where there are real differences in the parties and any conceivable basis for unequal treatment. However, intermediate scrutiny would be used by the court where state regulation allows men higher pay than women doing the same job. The two genders are similarly situated, and to prevail, the state would have to show an important purpose for the regulation, and show that the regulation was narrowly tailored to fit the purpose. This mid-level scrutiny is also applied for laws discriminating against illegitimate children and non-resident aliens. Strict scrutiny is reserved for cases of racial discrimination by the state, discrimination against resident aliens, this is green card holders, and discrimination preventing individuals from their fundamental rights, such as the right to marry and have children and divorce. It's not yet clear how cases of sexual orientation are to be treated. Government discrimination against gays and lesbians is an area that's currently unsettled in the law. Discrimination against resident aliens, green card holders, is tolerated by the federal government, but discrimination by state or local government is treated with strict scrutiny and generally found unconstitutional. So it would be unconstitutional for California to restrict attorney licenses to U.S. citizens, as this would not pass strict scrutiny of the courts. Non-citizens are allowed to take the State Bar of California and all other states. However, the state could restrict state jobs, such as police officers, to citizens of the United States, as the state could argue that security and other compelling reasons justify such a law. We've seen that racial discrimination is treated with strict scrutiny by the courts, and government laws discriminating on the basis of race are almost always struck down. However, many laws discriminating on the basis of race are upheld and found to be constitutional on the grounds they are intended to correct past wrongs. For example, laws forcing white children to be bused to schools that were primarily attended by black students were supported by the courts in the 1960s on the grounds that this was necessary to overcome the history of discrimination barring blacks from attending schools for whites. The only way to mix the population of schools was to force children of certain race to attend certain schools. Today, race can be considered as a factor for a university when admitting students. If the university wishes to increase the diversity of the student population, it's able to consider race as one of the factors when deciding which students to admit. However, race cannot be the only factor. This has been found to violate the individual's rights to equal protection. Overseas lawyers may be surprised to find that the US Constitution does not contain a provision providing equal rights for women. Women's rights are generally the same as those of men in the United States, but equality is not enshrined in the Constitution as it is in many other countries. There are several laws, federal and state, that protect the equal rights of women in such areas as work, voting, and property ownership. But the Equal Rights Amendment, first proposed in 1923, is still not part of the United States Constitution. It's been ratified by 35 of the necessary 38 states and may become the 28th Amendment. Under the Equal Protection provision, a law that discriminates on the basis of gender is judged with minimum scrutiny if the state has any rational basis for its policy and the men and women are not similarly situated. For example, state legislation forcing employers to provide separate bathrooms for men and women would be upheld as this is based on real differences in the parties and has a rational basis. Intermediate scrutiny is the test applied when laws or regulations discriminate against men and women in areas where they are similarly situated. For example, a state regulation forcing women to pass a driving test before being issued with a driving license, when no such test is required of men, would be subject to strict scrutiny. As the two genders are similarly situated when driving an automobile, and to prevail the state would have to show that an important state purpose for the regulation exists, and show that the regulation was narrowly tailored to fit the purpose. The reasons given by government for treating men and women differently have not been enough to survive mid-level scrutiny, and most laws discriminating without a strong justification have been struck down by the courts. Men and women are always treated differently, even when they appear similarly situated. Government regulation requiring men register for the draft in time of war, but not women, passed intermediate scrutiny and was upheld by the courts. The court also upheld a law discriminating against men in the areas of statutory rape. A man could be charged with rape when having sex with an underage girl, but a woman could not be charged with statutory rape when having sex with an underage boy. In each of these cases, the court found grounds for differentiating between the genders. Men are more suitable for battlefield combat, and teenage girls are more likely to become pregnant than their male counterparts.